Meeting is now being recorded.
Thank you, Madam Secretary. Good morning, trustees. Good morning, everyone. It is just a little bit after 9 o'clock. Thank you for your patience as we gathered everybody on Zoom. My name is Ruben Duran. I'm the chair of the State Bar Board of Trustees, calling to order the second day of our regular meeting for November 2022. For those of you who joined us yesterday to do all of the business that we did, which was quite a bit, I want to reiterate my thanks and appreciation for your input, your efforts, your patience, and really the hard work that is being done at the State Bar by our staff and with some guidance from the trustees. So for those of you who were with us, you will recall that we finished our open session items, all of the business that was on our agenda yesterday, which leaves us with our closed session agenda for this morning. With that introduction, I'd like the clerk to please take roll so we can get going.
Broughton, not present. Chen,
Here.
Cisneros,
Here.
Dela Cruz, not present. Duran,
Here.
Knoll,
Here.
Salag, not present. Shelby,
Present.
Soel,
Present.
Stallings, not present. Tony,
Present.
you have a quorum.
Thank you, Madam Secretary. So I do note that on our agenda yesterday was a public comment section, which is, of course, on every one of our agendas, required by law, and certainly I think required by this board's efforts to be open and transparent and welcoming of public comment on the business of the State Bar. I see that we have a few hands raised in the attendees list. And I do want to reiterate and reinforce that we are open and accepting of public comment. The items that are left on our agenda are closed session. And so if you are raising your hand to speak on a closed session item, I think the board would be open to hearing your input. Reminder that we've got 3 minutes per person. And I will just ask, with all due respect, if you're going to offer public comment this morning, you can see that our closed session items are listed on our agenda, and we would appreciate hearing from you on those items in particular. So with that, Madam Secretary, will you please prepare us for hearing closed session public comment. Charlene Duran, I'm not even going to try it. I apologize. When you come on screen, you'll see a 3-minute timer. You have up to 3 minutes to address the board. Thank you for joining us, and I apologize for not seeing your name correctly. Good morning.
Hi, good morning. Can you hear me okay?
Yes, we can.
Okay, thank you. And it's Dee Resendez, and thank you. And I do appreciate all the work that the committee is doing and that the staff is doing. But I would like to remind everybody that according to the Brown Act, public comment is supposed to be accepted, and it was not accepted yesterday. I waited for over an hour before you made the vote, and I was not called. So to be open and transparent, I sat on a committee in Sonoma County for the Open Government Task Force. And to truly be transparent is to invite people to speak, not just at the start of the meeting, but when the item is posted as well. And sometimes even after you guys have been able to talk about it, because things that come up when it's being discussed and presented is going to trigger additional things that people might want to talk about. So I'm going to just be real quick and use the rest of my time as efficiently as possible under 4.86 rule that is being requested to be revised for requesting subsequent testing accommodations. I applaud the staff and the committee for making revisions on testing accommodations. However, to single out people with the most severe disabilities, other than people who are blind, but people who have significant learning disabilities, cognitive disabilities, and physical disabilities, requiring them to submit additional extensive documentation for all subsequent tests that the bar already approved their accommodations for is punitive in nature. And I feel that it needs to be addressed and looked at further, please talk to people that have gone through this process before you make a decision that's going to impact people's lives in ways you can never truly understand. People commit suicide. Every testing examination, they attempt suicide. It affects people's lives vastly. I'm in my 50s. I have physical disabilities. I'm a high school English teacher. I went through law school in my 40s, and the California Bar approved my accommodations. If they approved it once, why do I have to show it again for a permanent disability? That, if nothing else, is going to take more staff time and resources than anything else. The last thing I would like to say is the fee. When a staff person makes a mistake and causes somebody not to be able to take the bar exam because they made a mistake and applied the wrong rule or policy, please refund our $870, because I understand not refunding it if the applicant made a mistake or didn't have a fully supplied documentation paper trail with their doctors, but every single application I've applied for in the last 3 years, the staff has made significant mistakes. They applied the wrong thing. They lost my paperwork. And I've had to pay nearly $900 plus $2,000 for hotel accommodations and food, transportation, that I'm out every single administration. If you truly want to
But
be
your time has expired.
If you truly want to be transparent and want to be inclusive, please consider all of the applicants. It's a very minor percentage of the total applicants.
Thank you, Ms. De Resendiz. I appreciate you, your patience yesterday and you're joining us this morning. I can assure you that we have certainly heard what you've had to say. That'll take us to Mr. Todd Hill.
Thank you and good morning. I don't believe I need 3 minutes this morning. I actually did not receive a copy of the closed meeting agenda items, and I was online this morning, and I did not see them there either. So perhaps someone could forward them to me, but it seems like they should be up publicly. That said, I actually want to speak to something that Mr. Tony said yesterday. And Mr. Tony, I'm going to say this because I really respect your input and commentary. But from my perspective, every meeting seeks to curb public comment. Part of it is for efficiency, but the reality is that for the vast majority of meetings that I've been in, I've been the only attendant. I've been the only attendee. So to curb public comment as if it's this major problem, yes, there's a hot topic item you've got right now. And obviously not everybody got to speak. So it seems that with every meeting trying to curb public comment, but there being active complaints about there not being reception of public comment or publication of public comment when it's appropriate. That seems strange to me. I remind you of your duty of inquiry, loyalty, fiduciary, and the special relationships that you've volunteered to take on. And for that volunteering, the state would normally give sovereign immunity for anything that was done as an error or omission, but in good faith. In this particular case, when is board action concerted action in good faith versus concerted action in bad faith or conspiracy? When is failure to act, when you have a duty to act, an affirmative omission and a breach of duty? Enron is a good example here, where the majority of the board members, but not all, participated in such things as document shredding, falsification of records, lying, all sorts of things. It was really crime after crime to hide, an initial wrong. And they were held accountable. Here, the first mandate is protection of the public before any other conflict of interest. The interest of efficiency is a great interest, but is it in the interest of the public mandate? Thank you.
Thank you for your comments, Mr. Hill. We'll move on to Benjamin Cohn. Mr. Cohn, welcome. Good morning.
Good morning. I commented yesterday before the board action that was taken, but I ran out of time, and I wanted to highlight that some of the additional reasons I disagree with the action taken to advance the existing proposal, or at least with continuing on this existing proposal for the testing accommodation rules revisions, the status quo that of referring and the petition that's being appealed to expert consultants already exists. The staff language acts like it's a new thing to that is a justification for eliminating committee of bar examiners review, that you're instead getting reviewed by an expert, but you would have before. You would have gotten the expert, then the director of admissions, and then only the CBE if that review didn't grant all the relief sought in the appeal. This is only eliminating panel review and the ability, more safeguard from errors. The time delay of doing it to a CBE meeting is only a problem because of the excessive staff review time per iteration, exchange of information and submission and perceived inadequacies that are sent back, which it takes months and deprives applicants of the ability to prepare with equal opportunity, as is the lack of collaboration. I'm very concerned that if that is the root cause of all of these things, and that if you held more special meetings and had the staff limited to 10 days, you would be able to have a CBE meeting if an appeal was necessary. Similarly, there's no reason for the current rule that oral argument is not allowed and there's no hearing. That would be one of the most beneficial safeguards, and yet that is doubled down on rather than removed in the current proposal. If you continue to proceed with these proposals, by the end of the process with the California Supreme Court, I expect that it may be preempted. You may have to start over because the legislature, the more they see that you're not fixing this, is getting more and more interested in my discussions with codifying what I've proposed into the State Bar Act and clearing up any remaining ambiguity after Brennan as to whether you're subject to UNRU by making it clear that you are. And those exemptions to certain government code accommodation requirements for licensure can be repealed too. Maybe before you finish.
Sorry, but your time has expired.
Mr. Comey, appreciate your comments. Thank you. We'll move on to Peter Maduro. Mr. Maduro, once your mic's activated, you've got 3 minutes.
Thank you. My name's Peter Maduro. I'm a clinical and sometimes forensic psychologist licensed here in California. I am also a licensed attorney in California as well as New York and Massachusetts. So I have firsthand experience of the process of taking the bar exam and the ordinary emotional impact it has, even for those of us who do not suffer from serious disabilities. In addition, in my clinical practice, I work with a number of disabled patients. A percentage of them have direct firsthand experience as candidates taking the bar exam and working through the process of trying to achieve accommodations for their disabilities. And in addition, I have more than one patient for whom the process has been tremendously emotionally traumatic as just a simple frame of reference. For a disabled person who in this world lives with a experience that the challenges that disadvantage them are not well understood and seen, the process of even the best intended efforts on your guys' behalf to find accommodations that try to even the playing field, but which fail in some fashion, can actually prove to be tremendously re-traumatizing. I'd like to stand in support of the prior speakers here, in particular, the first one is to alert you that the emotional impact of what it is you're out to do here can't be underestimated. And in that regard, and for that reason, the process of your being open to public comment and keeping the critical review of your process as well as the content of the proposals closely scrutinized can't be underestimated in terms of its importance. Now, in regards specifically to the proposals of the rule changes in respect of, I think they're 484, 5, and 6. I would like to offer a written commentary on those, which I'll provide the board as soon as possible. But again, I would like to encourage you guys to take very seriously the resources of critical comment and so forth. The stakes can't be underestimated. And I think that's, and I just want to say, in principle, what I'm aiming for here is to make sure that in your effort, well-intended as it may be, or compromised in any way by efforts at systemic efficiency, that you don't undo the very things that you're trying to
But
accomplish.
your time has expired.
Dr. Maduro, thank you for taking the time to join us and share your perspective. We look forward to receiving your written comments, and we'll be sure they're distributed to the entire board. Okay, our last public speaker this morning is Claudia Center. Good morning, Ms. Center.
Good morning. My name is Claudia Center. I'm the legal director of Disability Rights Education and Defense Fund. I've represented bar takers and LSAT takers for many years and was engaged as counsel for individual clients in the DFEH versus LSAC litigation. I think it is important that the state bar is referring to the LSAC consent decree and best practices report and the DOJ guidance, but the actual rules proposal does not track, in very, very significant ways, does not track the LSAC DOJ framework. The 5-year expiration date of prior accommodations is nowhere in the LSAC system. There's no reference to relevant standardized exams for test takers, bar exam test takers like the MPRE or the first year law student exam. Double time is not an exceptional accommodation that is automatically granted under the LSAC system. So it's extremely concerning that double time has been excluded from the automatic grants. There's no reference to deference to treating professionals. The LSAC consent decree included the addition of new consultants because the consultant pool was so essentially biased against granting accommodations, and there was ultimately new leadership at the LSAC and new training, new perspectives, and I think that needs to be considered strongly here as well. And there's also no reference, I may have said this already, deference to treating professionals and no reference to timed in-person closed book exams in law school and the accommodations granted there. So the packaging is good to track LSAC DOJ, but the actual contents don't do that. And we'll be doing written comments to that effect. Thank you.
Thank you. And we look forward to getting your written comments as well. Okay, I am going to announce the items that the board will discuss in closed session. They are as follows. We'll be talking about the Los Angeles Times versus State Bar case under the authority of Government Code Section 11126, subsection E1. We will also talk about the audit of closed Office of Chief Trial Counsel files under the authority of 1126A1 and sub C. And then we have a series of discussions on performance evaluation of the Chief Trial Counsel, the General Counsel, and the Executive Director. Once we've completed those items, we will reconvene an open session if they're to report whether there is any reportable action. Board members, I believe you should expect, if you haven't received it already, a separate closed session link. Madam Secretary, is that correct?
Yes, I just sent it, so it should be in your inbox.
Okay, wonderful. Thank you again, everyone, for joining us this morning. We will see the trustees and staff in closed session. Thank you. We are recording. Thank you, Madam Secretary. Members of the board, thank you for a very long and productive day in closed session. We have concluded with our closed session, there is no reportable action on any of the items. Thank you so much. Enjoy your weekend, everyone. We are adjourned.